All right, so why don't we get started? I know that folks will continue to trickle in, but like I said, I know this is everyone's, tends to be everyone's lunch hour. So I am mindful of everyone's limited time. Um, Good afternoon and welcome everyone. We're so pleased that you could join us today for our webinar on hot topics in employment law for Massachusetts charter public schools. I want to give a big thank you to the Massachusetts Public Charter School Association for inviting us to join you today. Just a reminder to folks that we're recording this webinar. Um, so I just want to say, Pat, can you just make sure that the recording's on, so folks, so
we are recording this webinar.
All right, great. I just want to make sure. I've done that before and not press record. So, anyway, welcome everyone. My name is Bettina Toner. I'm an attorney in the education and employment practice groups here at Krokidas and Bluestein. Here at K&B, we provide a full range of legal services to charter school clients. We have a fairly substantial charter school practice here at the firm. In my practice, I represent a number of charter school clients in a wide range of matters. So like I said, we're a full service firm for our charter school clients. So in my practice, I handle all sorts of matters, employment and HR matters, special education, general education, student discipline. I also work on organizational and board of trustees matters. And we also handle matters for mission affiliates of charter schools, so friends of organizations and all of the issues that they have in their roles, typically as nonprofits. So joining me today is my colleague, Jill Meixel, who's a partner with the firm. And I will hand it over to Jill so she can tell you a little bit about her practice.
Thank you, Bettina. Good afternoon, everybody. My name is Jill Meixel, and I'm the head of Krokidas and Bluestein's employment practice and the co-head of its litigation practice, where I represent schools, nonprofits, state agencies, for-profits, and individuals in a wide range of matters. I'm excited to be here today with Bettina and to delve into many important and prevalent employment issues which we routinely see in our practice and which we want to share with you today. Thank you for being here.
So you can see from the agenda, we have a number of hot topics to discuss with you today. I will say this was a really fun project for Jill and I to kind of put our heads together about, the main issues that we get. And of course, there are zillions, as you know, from your own work with charter schools. So we try to focus on issues that are ones that we receive a lot of questions about or have been getting a lot of questions about this school year, or things that have had updates to the law recently that you should be aware of. And as you know, of course, charter schools in Massachusetts have unique characteristics and requirements that differ from non-charter public schools. So while our discussion today is not intended to do a deep dive into any particular area, we wanted to take an opportunity to highlight some of the issues, like I said, that we've been receiving questions about or that we wanted to flag for HR staff. So with that, I did also want to say before we jump into the exciting topic of First Amendment issues, folks should feel free to put questions in the chat, or if you don't want to share your name or organization, you can put it in the Q&A. I think it's anonymous if you put it in the Q&A. We're going to collect all of the comments, and then what I like to do is to take all of the comments when I do a webinar and put it into a Q&A document, a written document that you can have and use as a reference. So we'll be collecting all the comments, all of the questions today, and putting those into a document that we'll distribute to folks along with the slide deck after the webinar. So with that, we will jump into First Amendment issues. So the first topic we wanted to discuss today is First Amendment issues. In my practice, I receive many calls from clients asking about how and in what ways a school can limit employee speech. So this can be things an employee says at school in the course of their work, or things that they say or post on social media outside of work, for example. And just a reminder, the First Amendment, of course, protects the right to freedom of expression and freedom of religion. And the U.S. Supreme Court has held that a government entity must provide substantial justification for any interference with the right of free speech. Free speech rights apply to all public employees. So oftentimes we talk about teachers in these presentations because that's a lot of times questions come up with respect to teachers, but it really applies to all public employees, not just teachers. So bus drivers, cafeteria workers, librarians, and so forth, administrators. So over the years, I won't do a deep dive into the case law because I know that that's not always as exciting to non-lawyers as it is to lawyers. But over the years, the Supreme Court has decided a number of cases that have established the framework for the analysis of speech made by an employee at work. So this is, a public employee. And those cases include Pickering and Connick, which are here on the slide. And together, Pickering and Connick established what we call this a two-prong test. So the first prong of the test when you're analyzing speech rights of employees is the speech a matter of public concern? What does that mean? So a matter is of public concern when it relates to any matter of political, social, or other concern in the community, or is a subject of legitimate news interest. So that's what a matter of public concern is. So the first prong of the test is the speech a matter of public concern? So in the Pickering case, that involved a teacher who had written a letter to the local newspaper in which he was critical of the school committee, claiming that the school committee was disproportionately spending on athletics over academics. So that's an example. So in Pickering, the court found that speech about that concern regarding school committee allocation of funding was a matter of public concern. So if the first question is it a matter of public concern? If the answer is yes, then you proceed to the second prong. If the answer is no, then it's not protected speech. Then kind of the analysis stops there. The second prong of this test is if the subject of speech is a matter of public concern, when it's in court, the court must balance the employee's right to free speech against the employer's interest in an efficient, disruptive workplace. This analysis can get tricky, as you can imagine, right? Because all of these cases are going to be very fact-based. So later in Garcetti, which was, Pickering was 1968, Connick was a little later in 83. If you get to 2006, when Garcetti was decided, and in Garcetti, the Supreme Court narrowed the test a little bit further by saying that when public employees make statements as part of their official duties, they are not speaking as citizens, private citizens, for purposes of the First Amendment, and the Constitution does not insulate their communications from employer discipline. So in other words, Garcetti simplified the test, this two-prong test, by shifting the analysis from the content of the employee's speech to the nature of the employment relationship. So employee speech on a matter of public concern is only protected if the employee is speaking as a private citizen and not as part of their official duties. So the question then is to ask is this type of speech typical as part of the employee's responsibilities? If it is, that speech is not protected. And we'll give some examples and talk about that a little bit more later. But again, this typically comes up when an employer wants to take some sort of adverse employment action against an employee, right? So either disciplining an employee or terminating an employee for something that the employee has said or written. I did just want to note, so here in the First Circuit, Massachusetts is part of the First Circuit Court of Appeals. The court decided an interesting case called Krokidas, and I did just want to mention it because it's an interesting analysis that includes speech rights of related to schools. So in Krokidas, the plaintiff was a speech and language therapist that was contracted by the school district to provide speech and language therapy and evaluations to students. So speech and language evaluations, and that's important. In the course of her work, the plaintiff had been telling parents that she didn't think that the school district was in compliance with state and federal law in determining eligibility for special education services. So my recollection is in the particular situation, she was opining about the school's overall eligibility determinations for whether a student is or is not eligible for special ed. So it wasn't specific to the speech and language therapies for which she was contracted to provide. So the school district got wind of the fact that she was sharing this information with parents, and shortly thereafter declined to renew her contract. She was a contracted employee. She filed suit, and the lower court found that the school district had retaliated against her by not renewing her contract. And in that case, using the two-pronged test, the Pickering-Connick test, had decided that the balance of interest tipped in favor of the plaintiff, of the speech and language therapist. The school district appealed, and the First Circuit Court of Appeals held that this was private citizen speech, which was protected. So it also held that the plaintiff, the speech and language therapist, had an interest in her own speech, just as a private citizen, but also that the public had a non-trivial interest in the information she sought to share. That is, that the school district may have been illegally denying special education students services to which they were entitled under the law. So the takeaway, and the reason I mentioned this particular case here in the First Circuit, is that the court declined to hold that she was making that speech in the course of her official duties. And so the takeaway is that the speech by public employees on matters related to their employment is not necessarily unprotected, right? So you have to consider whether the speech is made in the course of their official duties. So that's sort of a high-level overview of the analysis of First Amendment rights in the context of in-school speech. So how do schools balance those interests, the interests of employee speech and the school's interest? So some guidelines are things that the courts have set out to be considered are, is the speech made as a private citizen or as an employee, right? So that's kind of the situation that was being evaluated in Krokidas, right? Is the speech a matter of public or private concern? Where does the balance of interests tip between the employee and employer? In a number of these cases, I will just say, when you're balancing the employer interests, oftentimes the speech that gets an employee into trouble is speech that is critical of the employer, right? So, my supervisor is, not being fair, or the employer isn't fair, or wages are unfair, or something like that. So some of the other factors that courts consider, does the speech interfere with employees' performance? Is it affecting other employees? Did the speech create disharmony amongst staff? So is it creating a situation where people are not able to get their jobs done, or people are not getting along? Did the speech undercut an immediate supervisor's authority? And did the speech destroy a relationship of loyalty and trust required by the employee? So these are just some things to consider in evaluating free speech rights and that balance between free speech and the employer's interest. And of course, there's nothing preventing public schools from issuing policies concerning free speech in public schools, right? So the thing to just keep in mind is any policies restricting speech in schools must be reasonable in light of the purpose of the school, which is, of course, the education of young people, and they have to be viewpoint neutral. And I'll give some examples of some situations that have come up in my practice and how we analyze those in a sec. And this applies to policies and practices concerning staff or student speech. And I just mentioned that because that comes up a lot too. So what are the balances, for student speech or student free speech rights? Any policies, whether they're concerning students or employees, need to be reasonable, and they need to be viewpoint neutral. So I did want to, like I said, I did want to give a few real world examples of situations that have come up in the charter schools that I represent in my practice. We had a school where a number of parents had complained about a teacher who had displayed a large full-size flag with Trump's name on it on his car. He parked his car in the employee parking lot, but the way that the parking lot was arranged, parents had to drive through the past the basically pass a flag through the employee parking lot to drop students off or pick them up from school. And so the question came up, a number of parents complained about this, and the school raised the question of whether they could require the employee to remove the flag from his car, at least during school hours. And so in that situation, there are a number of things to think about, right? So the employee certainly has the right under the First Amendment to display the flag on their own time, right? And then the question is, what about the school grounds? So, I think in that situation, the way that we looked at it was, one, is it disruptive to the school environment? Did it appear to be on behalf of the school? And I think everyone sort of realized, this is a private person's car. It's not the school's, van or something that has the school's logo on it. And could this, has the school issued some sort of a policy that might prohibit it? So those are kind of the sort of three things to look at. Is it disruptive to the school environment? Does it appear to be on behalf of the school? And has the school issued a viewpoint neutral policy that would prohibit types of displays relating to politics or something like that? And in that case, we determined that this would be really difficult to do, keeping in mind that disruptive doesn't just mean that a lot of people don't like it. I typically think of disruptive as being something more along the lines of that material and substantial disruption standard, right? Is it causing a disruption to the learning environment, to the educational environment? And then with respect to the second prong, does it appear to be on behalf of the school? It was clear that it wasn't. And then did the school have a viewpoint neutral policy that might apply? And there again, I think where schools can get into trouble is having a policy that says no political displays or nothing controversial or things like that, and particularly with respect to employees' vehicles, right? So if you said you issued a policy that said no political displays on cars in the employee parking lot, that could be really difficult to enforce, right? So think about bumper stickers and things like that. So in that case, we determined that the school really didn't have a basis to prohibit the flag in the parking lot, even though they had received a number of complaints about it. Another couple, and just in the interest of time, wanted to give a couple of other examples. After George Floyd's death, there were a lot of questions that we got, and I'm sure you saw at your schools as well, about displays of support for the Black Lives Matter, and then what other balancing points of view were required to be displayed as well. Example of whether a teacher, for example, wants to post a Black Lives Matter sign in the classroom, can the school prohibit that? Or what if another teacher wants to display a Blue Lives Matter banner? The thing to just keep in mind again is that you can't limit specific viewpoints, but broader restrictions on school postings might be permissible if they're neutral on their face and applied consistently. So if the school permits Black Lives Matter signs, it probably can't prohibit other signs, that support other points of view unless they otherwise violate a school policy. And then the last one, I wanted to just give an example. What about situations where a teacher or administrator wants to wear a political button, either a button for a particular candidate or a button for a particular cause or against a particular cause? So one example would be a school librarian that wants to wear a pin that says no LGBTQ books in elementary schools. Could you prohibit that? In that situation, I think you probably could, particularly if there's a reasonable risk that someone might interpret that to be the school's position on LGBTQ books in elementary schools. And the other thing is that it might indicate a bias, a discriminatory bias on behalf of the individual that might be prohibited under one of the anti-discrimination laws, either under state or federal law. One other last example, what about political buttons? Like if a teacher wanted to wear, for example, a DeSantis 2024 pin. Courts have taken different approaches to this. A couple of examples I'll give is that Some courts have said that a school may prohibit teachers from wearing buttons supporting a current political candidate, so in a current election. In another case, a case out of New York, court did find that the school could require in an election year, that presidential election year, that a school could require a teacher to remove a picture of the incumbent president from the wall, unless they were willing to post the opposing candidates' pictures as well to create balance. And again, that's in an election year when the issue is kind of a ripe one. So I did also want to talk, so this comes up a lot too, right? So what about out of school speech? So we talked a lot about restrictions that schools can put on in-school speech. What about out of school speech? So social media and employee rights. So remember that for teachers and other school staff, speech made pursuant to one's official duties, generally not protected, right? We talked about that. And in Garcetti, the Supreme Court greatly restricted the freedom of speech for public employees, holding that speech pursuant to one's official duties that harms one's employer can lead to discipline. So an example of that might be a tweet or a Facebook post from an account identifying the speaker as a teacher at a particular school that is critical of the school may lead to discipline or termination if it could potentially damage the school, or if it suggests that the employee is speaking on behalf of a school. So again, these sorts of things can get tricky, and they're always going to be fact-based and when you're analyzing them. But one way to kind of address some of these issues or get out ahead of them is to be thinking about policies that say, for example, if you're posting outside of work on social media, don't identify yourself as an employee of the school or give any impression that you're speaking on behalf of the school. One thing I did want to mention, though, is that there are some protections under the NLRA, the National Labor Relations Act, which protects the rights of employees to work together to address conditions at work. So, for example, working together on issues regarding wages or working conditions. I do want to just mention that the NLRA has held that this protection of employees to be able to, collaborate and discuss things like working conditions and wages extends to work-related conversations on social media. Someone going on and talking about, unfair wages at a school is probably protected, if not under the First Amendment, under the NLRA. So there is that exception to keep in mind. So typically schools cannot regulate private speech by an employee that's outside of school or school-sponsored events, but some courts have upheld discipline for employees' social media postings when they've created disruption to the educational environment. We do get calls, I do field calls on these types of issues fairly frequently, just due to the volume of social media use that everyone has these days. So for example, social media posts that are racist or hostile to the Black Lives Matter movement or hostile to non-citizens or to English learners, to ELs, I think in those situations, you want to look at them and ask, what is the impact? Does it affect teaching? Does it indicate bias? And does it create a disruption to the school environment? So if you have someone that's working with, it has EL students or even if the school serves a number of EL students and a particular employee doesn't necessarily work with them, if they are posting online on their private account in a way that other folks get wind, so maybe other teachers are part of a Snapchat group or otherwise see it on Instagram or wherever, I think if there is if there's postings that indicate that an educator is biased in their views, that in a way that might impact their ability to work with students, or that may, if it spills over to the school environment, might create a hostile environment in violation of state or federal anti-discrimination laws, then it's probably not protected or it may not be protected. And again, all of these situations are, can be quite nuanced. And so when in doubt, we always advise, chatting with counsel about how to handle the employment aspects of that. I did want to also touch on political speech. So, this comes up fairly regularly, and I did want to just remind folks, of course, that charter school employees are considered state employees here in Massachusetts. And the Massachusetts State Ethics Statute restricts certain political activities by public employees. Specifically under Section 23B22 of the State Ethics Statute, there's a prohibition against the use of one's public position to engage in political activity, because a public employee who does so would be using their official position to secure for themselves or others, like a candidate or a ballot question committee, unwarranted privileges of substantial value that are not properly available to similarly situated persons. So, generally, public employees may engage in political activity, including political speech, if it's done in their own time, using their own not public resources. So that means not using your school issued laptop. However, most public employees may not engage in political activity during work time or using public resources for political activity. So one example I just thought of, because it's been in the news a bunch, is there is, of course, the Thrive Act and related bills that concern the abolishment of MCAS, right? So, teachers or other administrators that are interested in, working on that or a similar issue, things to keep in mind would be that a public charter school teacher or other charter school employee may support a local ballot question. They do it so on their own time and without the use of public resources. They can serve on a ballot question committee so long as they do so without pay and do not fundraise or act as agent for the campaign. And they may distribute campaign literature. You can do get the vote out calls or conduct campaign polls and so forth. Again, as long as it's on your own time and not using school resources, school copiers, that sort of thing. That's sort of the guidance for that. So in sum, how can charter schools stay one step ahead of all of these First Amendment issues? We always advise that schools regularly review school employee policies and procedures, as well as employee handbooks. Make sure all staff are trained on policies concerning employee speech and are clear on expectations. I always like to include in trainings for staff on sexual harassment and racial harassment, discrimination. Always just a reminder to folks that, this idea that generally your private, out of school speech is protected, but if you engage in speech or conduct that's harassing online and it spills over to the school, you may be subject to discipline. It's always a good reminder, and it's a good reminder to include that in your employee handbooks as well. And you want to, again, ensure that the application of school policies and procedures are consistently and fairly applied. So have good policies and make sure that when you enforce them, they're enforced in a way that's consistent and fair. And with that, I will hand it over to Jill, who is going to delve into some hot topics and human resource issues for you.
Thanks so much, Bettina. Hi, everyone. We are now going to turn to some hot human resources related topics. And as Bettina said at the outset, it was fun for us to put this presentation together because we could really sort of think to the issues that we're frequently faced with from clients. And so our goal here is there's a lot of information, but we're really trying to hit sort of the hot topics that we get the most questions about in our daily practice. My goal in this portion of the program is to focus on important human resources related legal issues that frequently arise in my practice, advising employers, including schools, and highlight some areas where you can take certain steps to reduce liability risk. I'm going to address numerous topics in this segment, and in particular, I'm going to discuss the following. First, I'm going to talk about best practices for managing employee performance issues. Next, I will discuss the intersection between an employee's performance and medical issues. Then I will discuss leaves of absences. Next, I will discuss reasonable accommodations. And finally, I will discuss the hot topic of wage and hour issues, at which point I will turn this back over to Bettina to talk about stipends and query issues. So as you can see, there's going to be a lot of information in these slides, so bear with me. Next slide, please. Bettina, oh, great, thanks. Now let's jump right in and discuss the first HR hot topic, which is best practices for managing employee performance issues. In my practice, acting as outside counsel for employers, the most frequent questions I get on a very routine basis relate to how an employer should properly address employee performance issues without going astray of the law. These questions often come to me at a point where an employer is at a breaking point with an employee who's not performing their job, and in the employer's mind, the situation has reached some level of urgency. The call I often get is, here are the facts. I want to know if I can terminate this employee right now, today. And if I do, what are the legal risks? While sometimes the situation is cut and dried, the majority of the time, this question requires further examination, where the goal is to decrease liability risk, which requires digging into sort of the facts and circumstances surrounding this employee's performance issues. All of that being said, as the employer, there are certain steps that you can and should take in the normal course that will make the answer to this question much less fraught and much more straightforward. Next slide, please. So first, I simply cannot emphasize enough the extent to which it is important to document employee performance issues, which is why I titled the slide Document, Document, Document. The most important guidance that I can provide here is to encourage employers to raise performance issues with the employee once a pattern of poor or subpar performance becomes apparent. In that context, you should understand the school's progressive discipline policy if the school has one, and very importantly, you should follow it. So for example, some progressive discipline policies may provide that where performance issues arise, an employee will be given a verbal warning or a written warning, and perhaps followed by an a performance improvement plan before termination occurs. If performance issues are ongoing, you should absolutely memorialize them in a biannual review or an annual review. And if the performance issues are very serious, you should raise the issue outside of the regular performance review cycle. From a legal perspective, it's incredibly important to document these issues to ensure that if the school ultimately needs to demote or terminate an employee, there is contemporaneous documentation of performance problems. You may wonder, why is this so important? Well, it's important because if after an employee is terminated for performance issues, the employee attempts to make an argument that their termination was actually because they were a member of a protected class, such as because of their age, because of their race, because of their national origin, because of their gender. For this reason, contemporaneous documentation of performance issues will help the school show that it actually had a legitimate legal business reason to terminate the employee. So I found in my practice, it is really common for employers to shy away from providing accurate, honest feedback in performance reviews or otherwise, even where there are significant performance issues. Employers and managers often are afraid of hurting employees' feelings and don't want to face the discomfort of relaying negative feedback. As a result, two things happen. First, performance reviews often do not accurately reflect the employee's challenges in a role. And secondly, when these performance issues are allowed to percolate, there often comes a moment where the employer wants to take immediate action in the face of no documentation at all or warnings. While no one wants to hear negative feedback, there is a way to convey this in a professional, non-confrontational, constructive way, which ultimately will both help the employer and help the employee as well in efforts to try to improve their performance. Ultimately, honest feedback that's memorialized in writing, relayed in a professional manner, is very important, and it serves many important purposes. It brings the employment performance issue to the fore and ensures that employees are aware of any issues. This information, again, as I just said, will hopefully lead to an employee's improved performance, so everybody can move forward and assist with the school's daily operations in the most effective way possible. And finally, as I said earlier, conveying this feedback, even if not the most enjoyable thing, protects the school in the event discipline or termination becomes necessary, reduces liability risk with contemporaneous documentation, showing that an adverse action, i.e. termination, demotion, is not based on an employee's membership in a protected class. Next slide, please. Now I would like to address a common scenario that I see in my practice. As I mentioned at the outset, I frequently receive calls from clients indicating that they need to terminate an employee and seeking ASAP advice on the associated risks. And this scenario often plays out as follows. Employee calls asking for guidance on this issue. The employer indicates that there are performance issues of a particular employee that are ongoing for a long time, and they want to terminate that employee immediately. Key consideration here is, are the performance issues well documented? The frequent answer that I often hear is one of two things. It's either no, we haven't been good about it. There's no documentation. We might have said something to the person here or there, but there's nothing in writing. Performance reviews are all glowing, would be the second option. Maybe not glowing, but there's nothing negative in there that would lead to the conclusion that this employee was on the brink of being terminated. Neither of these scenarios is preferred. Ideally, as the employer, you're in a position where these performance reviews have been well documented over time, and there's clear support for subsequently taking an adverse action if you need to. Next slide, please. Now I'd like to stop and focus on why there is a potential for increased liability risk in terminating an employee for performance-related reasons where documentation is significantly lacking. You may be thinking, why does all of this documentation really matter if it's so clear to the managers and supervisors that the employee simply isn't performing their job? By way of backdrop here, I am assuming that this employee is an at-will employee and doesn't have an employment contract specifying if and when the employee can be terminated. So even though an at-will employee can, in theory, be terminated for any reason or no reason, this still does not in any way eliminate liability risk. For example, even where an employee is at will, the employee cannot terminate the employee for a discriminatory reason in violation of state or federal anti-discrimination laws. In evaluating the risk of terminating an at-will employee, an employer needs to understand whether that employee could have some argument that their termination was not for performance reasons, particularly where there's no documentation of performance reasons, but was based on the fact that the employee is in a protected class or engaged in some sort of protected conduct. Next slide, please. So here's an example. Let's say that you have 6 employees in a department. You have 5 men, you have 1 woman. It could be that you have 5 white people, 1 person of color. Could be, you could change those protected classes to a host of different ones as a demonstrative example. All the performance reviews of these 6 employees are essentially the same. There's no criticism in any of them, nothing that would lead you to the conclusion that these employees were on the brink of termination. The employer wants to terminate an employee, and it happens to be the female employee. The employer says there's a history of poor performance, but as I said earlier, there's no indication of that in the annual performance reviews or otherwise. That employee could claim that they are actually being terminated because of their gender. All the performance reviews are similar, and the woman, unlike the 5 men, is in a protected class. So this just adds a layer of challenge that would be completely unnecessary if all of her performance reviews challenges were well documented. So even though that the termination was due to performance issues and not gender, the door here is left open for the employee to make an argument that, especially where there's insufficient documentation, that the reason for termination was based on the fact that she was in a protected class as opposed to because of poor performance. Next slide, please. So next, I'm going to discuss the intersection between performance issues and medical issues. And I raise these handful of slides because this is an issue that has started to frequently pop up, really frequently pop up. I get questions about the intersection between an employee who is performing poorly, but is on the brink of taking a leave of absence for a medical issue or just returned from a leave of absence. So I really wanted to dig into this a little bit. So specifically, I often hear from employers who want to take action against an employee for poor performance in the face of that same employee's medical leave or other issue which will require a protected leave of absence. These situations really need to be handled with particular delicacy so that there is no ambiguity that any employment action taken against an employee is wholly distinct from a medical issue or a disability. Next slide, please. So now I want to talk a little bit about the complex issue involving the intersection of performance and medical issues. So where an employee concurrently has performance and medical issues, as I said on the prior slide, an employer really needs to proceed cautiously so they don't take any action that could be interpreted as discriminating on the basis of a disability. It's extremely important that if an employer needs to take an adverse action, such as a termination, against an employee who has a pending leave of absence and also performance issues, that the evidence is clear that the termination is due to performance and not disability. So the intersection of these issues typically arises in two contexts. One is when an employee is about to take or has just taken a leave of absence under FMLA, PFMLA, one of the leave laws. And the other is where an employee seeks a reasonable accommodation under the Americans with Disabilities Act. And I will just say here before we go to the next slide that this kind of circles back to my point about documentation, that documentation is just so important for so many reasons, because in the course of an employment relationship, you just don't know how things are going to play out. And so while someone may be a stellar performer in one instance, tides could turn, there could be subsequent issues that arise down the line, and you just want to make sure that you're covered. Again, the goal here isn't to just overly criticize employees. We want to boost employees' morale. We want to boost them up and help them perform better. But there are some instances where it's just critical to document in order to protect yourself. So now I want to get in a little bit to leaves of absences generally, and why employees sort of take leaves of absences. The intersection of these performance and medical issues raises liability risk specifically related to disability discrimination. In other words, if an employer takes an adverse action against an employee for performance-related reasons in the face of a leave of absence or a disability, the employer needs to take careful steps to document the cause of the adverse action, i.e. performance. So there is a variety of reasons why an employee takes leave and laws under which they can take this leave, including under the FMLA, PFMLA, Americans with Disabilities Act, Massachusetts Parental Leave Act, for various reasons, including but not limited to parental leave, bonding leave, one's own serious health condition, the serious health condition of a family member. I do want to just highlight, this is slightly sort of off the topic, that when you draft and review your employment policies, it's really important to make sure to include a statement that indicates that leave under any of these laws, whether the FMLA, PFMLA, or the Massachusetts Parental Leave Act, shall run concurrently where applicable, because if that language isn't in the handbook, an employee could interpret the laws such that they could take a 12-week leave under the FMLA if you're an employer with over 50 employees, and then another 12-week leave or 20-week leave, whatever the case may be, under the PFML, because there isn't explicit language indicating that these leaves run concurrently. It's a simple thing to do, but it can be easy to forget. So I just wanted to use this opportunity to remind everyone of that. Next slide, please. So I want to talk for a couple minutes about the Paid Family Medical Leave Act, which has sort of changed the way leaves work in Massachusetts with, paid leave now in the state. So under the Paid Family Medical Leave Act, as many of you likely know, employees are eligible for up to 26 weeks in a benefit year of leave, up to 12 weeks for bonding leave, 12 weeks to care for a family member with a serious health condition, and up to 20 weeks of leave for an employee's serious health condition. Next slide, please. So again, here, just to sort of get us situated, we're talking about the intersection between performance issues and medical issues. And this really is, the Paid Family Medical Leave Act, this issue really comes to the fore. So a clear example of where an employee's medical and performance issues intersect arises in the context of an employee's leave under the Paid Family Medical Leave Act. This intersection comes into play when an employee has serious performance issues either before they take leave or after they return. Under the PFML, which many people don't know this, but there is an automatic presumption of retaliation by the employer if the employer takes an adverse employment action against an employee within a certain period of time after they return from leave. Essentially, this means that if an employer takes an adverse employment action, meaning a demotion, a termination, any change in status or benefits, within 6 months after they return from leave, there is an automatic presumption that the adverse action, termination, demotion, et cetera, was taken in retaliation for the employee's leave of absence. So that's a pretty big deal. So just to say it again, if you take an employment action against an employee who is within 6 months of their return from leave under the Paid Family Medical Leave Act, there is an automatic presumption against retaliation. So this means you have to be even more careful with documenting performance issues, because who knows if somebody's going to go on a leave of absence. And you want to make sure, to the extent someone does go on a leave of absence and they're having significant performance issues, that within the 6-month period after they return, that you have solid documentation to justify having to take an adverse employment action. So this does not mean that you can never discipline an employee in the 6 months after they return from leave. So now this really comes full circle to my original slides. This does mean that you need to be vigilant about documenting performance issues at all times, including before a leave, even when you have no idea that a leave is going to be on the horizon, as well as afterwards, so that you can overcome this presumption if you need to demote or terminate or change the position in an adverse way of an employee. So I want to just look at this slide. So what this slide is it's a excerpt from the actual Paid Family Medical Leave statute. And this is essentially laying out this presumption of retaliation. And what it says, just to sort of, so you can see the specific language, is that any negative change in the seniority, status, employment benefits, pay, or other terms or conditions of employment of either one, an employee which occurs anytime during a leave taken by the employee, or during the 6-month period following an employee's leave or restoration to a position, or an employee who's participated in proceedings or inquiries pursuant to this statute within 6 months of the termination of proceedings. And that's essentially if somebody makes a complaint, about a violation of the law, files a complaint against the employer. A negative change shall not include trivial or subjectively perceived inconveniences, et cetera, et cetera. And then this part that's highlighted in red is the really important part. Such presumptions shall be rebutted only by clear and convincing evidence that such employer's action was not retaliation against the employee, and that the employer had sufficient independent justification for taking such action and would have in fact taken such action in the same manner and at the same time the action was taken, regardless of the employee's use of leave. So again, this really just highlights the point that documentation is so critical, because if an employee is having performance issues and you're documenting all along, then you'll be in a better position to overcome this presumption by clear and convincing evidence, because you'll have documentation to show that these performance issues weren't simply created out of the blue when somebody was on a leave of absence. Next slide, please. So now let's take a look at an example to see how this plays out. So let's assume the following. An employee has ongoing performance issues over a lengthy period of time. The employee subsequently informs the employer that they need to take a leave of absence due to an illness. The employee is subsequently on leave for several months. Consider which of the following scenarios has the most significant liability risks. So let's look at scenario one. So scenario one, the school doesn't have much documentation at all of performance issues before the employee took the leave. The school may or may not have engaged in some brief conversations with the employee about them, but there's no documentation at all. The employee then comes back from a job protected leave, and the performance issues are ongoing. Let's say a month passes. It could be 2 months, it could be 3 months. The school wants to terminate the employee. The school says the supervisor just can't work with the employee any longer, given these performance issues and the employee's inability to get anything done. So that's scenario one. Scenario two is, before the employee takes this leave, the school repeatedly documents serious performance issues over a lengthy period of time. The school puts the employee on a performance improvement plan, tries to work with the employee to improve performance. The issues are very well documented. The employee then takes the leave, a job protected leave under the Paid Family Medical Leave Act, and returns, and the performance issues continue. 4 weeks pass, could be 8 weeks, could be 12 weeks. The school wants to terminate the employee, saying the same thing as in scenario 1, supervisors simply can't work with this employee any longer. So scenario 2 clearly presents a significantly reduced liability risk for the school if you want to terminate this employee within this 6-month period, the 6-month presumption against retaliation. Scenario 2 clearly presents significantly less risk, especially if the documented performance issues were before the employer ever even knew of the leave. So this presents a really solid basis to overcome the presumption in the Paid Family Medical Leave Act where these issues are significantly documented. And just to sort of refresh, we talked about the standard for the presumption against retaliation can be overcome with quote unquote clear and convincing evidence that such employer's action was not retaliation and had sufficient independent justification. So if you have a file full of, documented performance issues both before and after leave, this is going to allow you to more readily overcome that presumption. Next slide, please. So now I want to turn to another way in which performance issues and medical issues can intersect. We've discussed now how a leave of absence can impact discipline for performance-related issues. And now I'd like to address reasonable accommodations under the Americans with Disabilities Act. A reasonable accommodation is a change in a job or the way the job is performed that allows a qualifying disabled employee to perform the essential functions of their job. Where an employer is made aware of a disabled employee's need for an accommodation, the employer and the employee can get together and engage in what the legal term is interactive process to determine whether there is a reasonable accommodation that will allow the employee to perform the essential functions of the job. So this is essentially the employer and the employee having a conversation to try to figure out whether there's some accommodation that will help the employee to be able to perform. I will note here that it's really important to update job descriptions to include essential functions of the job. And I always advise that it's helpful to actually include a section in the job description that says the words essential functions of the job. Because in scenarios where you have an employee who seeks an accommodation, of course, we want to try to accommodate the employee in whichever way we can, but there could be a scenario where the accommodation just doesn't enable there's no accommodation that enables the employee to perform the essential functions of the job. If those essential functions are very clearly laid out, it makes the analysis and the liability risk lower. So reasonable accommodations, as you may know, come in many forms. It could be an accommodation to the conditions in the workplace, such as if I have carpal tunnel and I need a different keyboard, that's one basic example. Or it could be a modification of job duties, such as, a structured schedule or somebody who needs to go to weekly physician's appointments, having weekly meetings with supervisors because somebody needs sort of executive functioning help, for example, or a leave of absence, which can also be a reasonable accommodation to a disability. Next slide, please. So now I'd like to address the process that I typically recommend that employers follow when an employee requests a reasonable accommodation and how this will play out. So employee will come to the employer and ask for an accommodation. The employer should request that the employee obtain information from their healthcare professional regarding the employee's limitations, so what they're not able to do as a result of their disability, suggested reasonable accommodations, and how long the reasonable accommodation will be necessary. It's also important to have the employee provide the healthcare professional with a copy of the job description so that the healthcare professional can understand exactly what the job duties of the employee are. Oftentimes, the employee might not convey it in the same way that the employer would convey the job duties. And so providing a copy to the healthcare professional takes away any ambiguity. The employee then tells the employer what the response from the healthcare professional is. It's typically in the form of either a letter or a form where the healthcare professional gives some more information relating to the employee's limitations. Then the employer and the employee engage in what I referred to before, the interactive process, to try to figure out whether there's an accommodation that will allow the employee to perform the essential functions of their job. And as you won't be surprised to hear me say at this point, really important to document the entire process, because there may come a time when the accommodation, if you provide one, if you determine there is a reasonable accommodation, is either no longer reasonable, or if the employee is not able to perform the essential functions either with or without this accommodation, and you need to take some form of adverse employment action. Next slide, thank you. Now let's discuss an example of the intersection of performance issues with the ADA. So here's another example. So let's assume an employee has a history of performance issues, and the employee discloses that they have PTSD and they require some accommodations. The employer thereafter provides these accommodations, for example, breaks during the day, time off for appointments, a quiet workspace, a flexible schedule, but the performance problems continue. The employer determines that the employee simply can't perform the essential functions of the job either with or without a reasonable accommodation. So in this circumstance, if the employer terminates the employee, the memorialization of the performance issues, again, will significantly decrease any liability risk, because it'll show that the adverse action is totally unrelated to the disability and related to the fact that the employee simply cannot perform the essential functions of the job. Next slide. So now I'm going to completely switch. I know that was a large amount of information. And now I'm going to give you more information, but this time on a new topic, which is wage and hour issues. And, we could spend a whole day talking about wage and hour issues. So I've really just tried to hit the high points here to give you some guidance on a few areas that Bettina and I routinely see in the course of our practice. Next slide, please. So here, I wanted to flag a key reminder relating to how and when to pay an employee who is departing either through a termination or through a resignation. And this is really important because, again, I'm focused on sort of liability risk to the school. And there's the Massachusetts Wage Act provides specific requirements as to when employers, need to pay departing employees. So many of you may know this already, but I think it's really important because the liability that could result from not following this rule could be pretty significant. So if an employee is terminated, all outstanding wages are due on the day of that termination, including accrued vacation time and PTO, which is included within the definition of wage. Separately, if an employee resigns, in that circumstance, an employer must pay all wages on the next regularly scheduled pay date. So what are the consequences of a late payment? The consequences of a late payment, either for a terminated employee or for an employee who resigned, is treble damages and attorney's fees. And this is if an employee decides to pursue the matter and file a complaint with the Wage and Hour Division of the Attorney General's office, or to bring an action in court. And I will say here that this is the strict liability statute, which means there's no defense, essentially. So if as the employer, you just make a mistake and you accidentally pay a terminated employee on the day after they were terminated, and it was a mistake, it was an accident, that still would implicate treble damages. And these numbers could get particularly high where an employee has a large amount of vacation time and PTO that needs to be paid out. Oftentimes employees don't really know that this law, and they don't necessarily go and pursue it. But the times when this tends to be pursued, in my experience, is when an employee leaves an employer's work site under very bad terms, and which hopefully, again, never happens, but it unfortunately does, just as part of doing business and operating. And the employee is looking for a reason to sue. And if an employee either knows on their own or hires an attorney, the attorney will know this law, and it could result in some liability for the school. So I would just, that's an important piece of information that I wanted to bring to everybody's attention. Next slide, please. Another important topic that frequently arises relates to when employees are exempt from overtime. So under the Fair Labor Standards Act, which is a federal law, there are certain exemptions to overtime. And employees can be exempt from overtime if they qualify for a certain exemption under the Fair Labor Standards Act, such as professional exemption, administrative exemption, etc. Or a teacher exemption is a separate exemption as well. The annual salary threshold to qualify for some exemptions is presently $684 a week. However, I do want to note that teachers are exempt, and the salary and salary basis requirements do not apply to bona fide teachers. Teachers are exempt if their primary duty is teaching, tutoring, instructing, or learning or lecturing in the activity of imparting knowledge, and if they are employed and engaged in this activity as a teacher in an educational establishment. So that's an important point for all of you, but there are obviously many people who work in schools who are not teachers, at which point we need to look carefully at whether there's an exemption that applies, and if so, which one. So potentially on the horizon, the Department of Labor has proposed changes in the salary threshold for exemptions to $55,068. And I should note that putting teachers aside for certain other exemptions like professional exemptions, administrative exemptions, there's two different prongs that need to be met to qualify for this exemption. One is the annual salary threshold, which I have noted here. And the second is each of these exemptions have certain job duties tests. So you have to do an analysis to see whether or not certain employees qualify. Why is this important? This is important because if you misclassify an employee as exempt from overtime, and that employee routinely works more than 40 hours a week, then they are not being paid for time that they would otherwise be entitled to be paid as a non-exempt employee. So it is very important to do an analysis of your employees to determine what their proper classification is to, again, reduce liability risk so you don't find yourself in a situation where an employee has been classified as exempt, but is actually entitled to overtime, but hasn't been paid it over some lengthy period of time. So now I'm going to turn this back over to Bettina to talk about stipends.
Thanks, Jill. So stipends, always an interesting issue, and I think one that many charter schools are familiar with, but maybe some are not. But frequently, of course, as you know, many times employees at charter schools have multiple roles, right? So you might be a teacher during the day and have a stipended role as a coach or as an after-school tutor. And just I wanted to flag some important points of things that you should be aware of with respect to compliance with the state ethics law on that. So as discussed earlier, charter school employees are state employees subject to the state ethics law. So the rule is under the state ethics law that a public employee may not have a financial interest in a contract with an agency at the same level of government unless an exemption applies. So what this means is that a charter school employee cannot have a second paid arrangement with the school for which they are paid separately. So this is important. So how do you fix the problem of two contracts? It's easy, but it's important to do. So any offer letter or agreement for a stipended position should be sure to include a language that makes clear that it is an amendment to the original agreement, the original offer letter, original letter of agreement for the employee's primary role at the school. And that the stipended position, the letter of agreement for the stipended position supplements the original offer letter or letter of agreement. So I've included some language here, and again, you'll get the slides if you need this language for your own agreements. But typically just include some language that says that this offer letter is intended to be read as an amendment, which supplements the terms of your offer letter dated whatever date, and together are intended to constitute a single contract for purposes of Section 7 and Section 20 of the state ethics statute. So that's a quick and easy way but an important way to make sure that you don't have, your employees don't have two contracts with the school. Very important to keep in mind. I always like to kind of flag that for folks. And I did also want to touch on CORI issues. I feel like for some reason this school year, I've had a lot of questions about the CORI process. So I wanted to touch on that just to kind of review some guidance from DESE and also the law with respect to criminal offender record information. So of course, all charter schools are required by law to have a written CORI policy. That's assuming you run 5 or more criminal background checks a year. I assume most schools here do do. So, and it's good practice anyway, right? So charter schools are required by law to have a written CORI policy. Generally, that's included or should be included in the employee handbook. The CORI statute includes volunteers who may have indirect and unmonitored contact with children. So that's important to keep in mind as well. So it's not just your own staff, but it includes volunteers as well. And DESE has an older advisory on CORI law, but it's still up there, still good law, still good advice in it. It's set up in a Q&A format, so it's pretty helpful. I reference it, often because it does have some good information. So that's from May of 2007, but some information in there that's important to highlight. Reminders that the CORI should be the last step in the screening process, right? So it should only occur when an applicant is otherwise, the school determines that the applicant is otherwise in all respects qualified for the position. It doesn't provide guidance. That DESE's guidance does not provide guidance or advice on how CORI information should affect hiring or employment decisions, but sort of recommends to schools that they consult with counsel if unsure how to proceed after receiving an applicant's CORI results. And again, I would sort of make the pitch if you're not sure if information included in a CORI, justifies not hiring someone, or what I think where this comes up, at least last year and this year, sort of post-pandemic, all schools are really struggling with staffing, right? So, they may be making choices about potential hires, that they, for folks that they may have otherwise just screened out in the past. So I've been getting more questions like, can we hire this person? Are there any risks in this? And again, there's DESE doesn't give any hard and fast rules. The CORI statute and regulations don't give any hard and fast rules. But when in doubt, I always suggest, talk to counsel. It's always helpful to kind of talk through, what the results mean, and what are the relevant aspects of the information that you have in making an employment decision. So what are some factors to consider when you're reviewing a CORI record? You obviously want to consider the type of offense. Is it a felony or misdemeanor? The nature of the offense. Is it domestic violence? Is it assault and battery? Is it forgery? So whether the charge resulted in a conviction. And if so, what type of sentence was there? Was the did the individual successfully complete probation? What are the dates on the offense? Are all things that are on the CORI like 10 years ago more, when the person was, maybe in their early 20s and now they're like in their late 30s. I mean, all of that information is relevant and important to take it, in its totality. And whether the individual has been arrested subsequently. Is this a CORI that has lots and lots of felony offenses and convictions, or is it, something that happened a long time ago, but then maybe there's something more recent that's particularly concerning. And then I think, the other thing obviously to keep in mind is, are there unique aspects of your charter school, the students that you serve that might make this person and their, criminal history problematic. So you want to consider your student population, the health and safety needs of your student, and other relevant policies and procedures, kind of what capacity will this individual be working with students? Is this a teacher? Is this a bus driver? Is this somebody that's not going to be working directly with students so much? All of those things are important to keep in mind. And of course, this typically comes up in the context of a potentially adverse employment action, right? So if a charter school intends to take an adverse employment action concerning a potential employee, such as not hiring the person, right? Based on information in the CORI or other criminal history information, there are a number of steps that the school must comply with. And again, these should be in your CORI policy and should be in your employee handbook. This should all be information that if someone wanted to find it, they could easily access it. But steps that the charter school needs to take. So obviously, if you're considering taking a potential adverse action, you want to notify the person immediately, provide the individual with a copy of the CORI, including the source of the CORI, so where you obtained that from. Identify the information in the individual's CORI that's the basis for the potential adverse action. And I can't overemphasize that when you usually we have a form of letter that I use, and we use a KMB for our clients that kind of make sure it kind of includes all of this information. And I always make sure to emphasize that it's important to say, what aspect of the CORI, not just based on your CORI, so in other words, if it's, the 2 recent felony convictions for assault and battery, or whatever it is. And there are certain things you can't sort of screen someone out for on their CORI, certain misdemeanors and so forth. So, but you do need to be specific. You can't just say, we're not hiring you based on your CORI. So that's important to include. Providing the individual copy of the school's CORI policy and allowing the individual an opportunity to dispute the accuracy of the CORI. And all of these requirements are by regulation under state law. Allowing the individual an opportunity to dispute the accuracy of the CORI. I sometimes get questions from folks. It's not, you have the opportunity to dispute the accuracy of the CORI, and you need to give the individual information on how to do that. So that information is, with the link in the next bullet. It's not an opportunity. So if there's something that's just wrong in the CORI, it's not me, it's, that's, they have a mistaken identity or something like that. It's not an opportunity necessarily to dispute your decision based on the CORI background. So I just always like to kind of clarify that, because I think that can be confusing for folks. And then, of course, in line with all of the advice that Jill has given with respect to other aspects of HR actions, you want to make sure to document each step. So usually I put a lot of this information in a letter to the individual. Again, you do the same process, whether it's an employee you're not hiring or a volunteer you're declining to allow participate. I've actually had a few individuals this year who wanted to be volunteers that we, based on their CORI, just said no thank you. But you do need to give them the same notice and comply with the same aspects of the regulation, so that's important to know. But it's good to have a form letter that kind of sets this forth, so it's kind of a reminder to you as you go through and give the person notice and attach these policies and information and so forth. All right, so I'm mindful of the time, but I do want to make sure that we have some time to touch on a couple of recent Supreme Court decisions that folks may be familiar with or have heard a bit about. So the first one is the 2 SFFA cases that the Supreme Court heard earlier this year, which relates to affirmative action programs in higher ed. Right. So why is this relevant to schools? I think it's relevant to schools as employers as well as other employers. So I think it's worth mentioning because it's a little unclear where things are headed, but there's some things that schools should be thinking about now. So just by way of review, at the end of June, the United States Supreme Court held in Students for Fair Admissions, Inc., the President and Fellows of Harvard College, and SSFA v. UNC, that race-based admissions programs violate the Constitution's Equal Protection Clause and Title VI of the Civil Rights Act. So even though the decision included an important provision that universities may still consider an applicant's discussion about how race affected his or her life, the decision, of course, represented a dramatic departure from the court's long-standing precedent up until that point, authorizing the use of race, consideration of race to promote diversity in making admissions decisions by schools, colleges, and universities. So of course that relates to colleges and universities higher ed, but while the SFFA cases were limited to college admissions, I think a lot of folks felt that that decision signaled that there were additional challenges to affirmative action and diversity, equity, and inclusion efforts by employers that may be on the horizon. So of course there's been a lot of talk about that. Folks have probably seen that in the news, and even some cases that were brought subsequently against a couple of the bigger law firms, which have, I think, mostly settled out. But I think it's a signal that there are going to be some challenges to these programs. So before everyone panics and says, what should we be thinking about now? There are some things to be thinking about, but I do want to remind folks that employers, charter schools as employers, like all employers in Massachusetts, are subject to the anti-discrimination provisions of Title VII, so a different section of the Civil Rights Act of 1964, and then a similar Massachusetts statute, which folks are probably familiar with, Chapter 151B. So notably, the Supreme Court decision in the FFA SFFA cases did not consider affirmative action initiatives in the context of Title VII in employment. They were Title VI cases, dealt with higher ed. And in fact, following the Supreme Court's ruling in those cases, the EEOC chair issued a statement making clear that the ruling does not address employer efforts to foster diverse and inclusive workforces or to engage the talents of all qualified workers, regardless of backgrounds. And also, she issued a reminder that it's lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded an equal opportunity in the workplace. All of that said, I think there is a lot of thought being put into, what's next and what changes might employers need to make with respect to DEI efforts. So it's important, I think, for schools as all employers should to be thinking about these issues. And so with that said, what actions should charter schools consider taking now? So while it's important to continue DEI efforts across staff hiring and other staff and student programs, now is a good time to review existing DEI programs, initiatives, and related policies, and ask some questions. So, are existing DEI initiatives such as targeted fellowships and internships expressly limited to particular racial groups? If so, are there other means by which the employer, so here the charter school, can support and improve diversity through efforts that are not expressly based on race or national origin? So do current employment policies and employment handbooks require updating to address some of those concerns to make them a little more litigation proof? And are trainings for human resource staff needed to ensure that hiring recruitment practices focus on efforts to increase diversity that incorporate factors that are not limited to race or other protected categories? So it may be, in practice, not a lot needs to change, but maybe there's some language in your employee handbook or in relation to some of your DEI efforts that need tweaking. So it's just worth giving some thought. I mean, I think that, no one's, nothing needs to be done sort of immediately, but it's good to be giving some thought to some of these issues of like where there may be a vulnerability. The other thing I always, like to remind folks is that recruitment efforts may still target individuals of a particular protected class. So you're welcome to go out and recruit at, particular colleges or particular targeted recruitment fairs to try to shore up, the DEI makeup of your staff. I mean, your recruitment efforts can continue in that way to target particular protected classes. It's just your ability to, require that someone be a member of a particular class for any particular position, whether it's a teaching fellowship or an internship or any kind of particularly targeted program, could come under scrutiny at some point. So it's good to be thinking about those things. So I'm going to turn it over now to Jill, who's going to share some updates on religious accommodations in response to some Supreme Court decisions the Supreme Court decision that recently came out as well. So I'm going to hand it over to Jill.
Thank you, Bettina. So this is our last topic of the day, which addresses religious accommodations and recent Supreme Court clarifications to the law in that regard. So the Supreme Court has recently come down with a decision that significantly impacts employee requests for reasonable accommodations in the workplace. So before we review some facts of that specific case, I just want to review the relevant legal authority. So we're back talking about Title VII of the Civil Rights Act, which provides that it's unlawful for covered employers to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's religion. So this requires employers to accommodate employees' religious beliefs and practices unless it would impose, and this is a key term that was at issue in the recent Supreme Court case, unless it would impose an undue hardship on the conduct of the employer's business. So this is what the dispute was about in the Supreme Court case, i.e. what does that mean? What is undue hardship? What does that mean? So that term is not defined in the statute. And since many decades ago, undue hardship was interpreted to mean any effort or cost that is more than a de minimis cost. So this was an extremely low bar that since the 70s has been what the court has required employers to use as its threshold for determining whether or not to permit religious accommodation. Next slide, please. So now I just want to go over the facts of this 2023 Supreme Court case. It's called Groff versus DeJoy, the Postmaster General. So in this case, Groff was an evangelical Christian, was unwilling to work on Sundays as a mailman because of his religion. Initially, when he was hired, there was no work on Sundays required, but at some point, the Postal Service agreed to help facilitate deliveries for Amazon on Sundays. So at that point in time, Groff was asked to start working on Sundays, and he declined, saying that he needed an accommodation because of his religion not to work on Sundays. His work ultimately was performed by other employees. As a result, his employer disciplined him for refusing to work on Sundays, and eventually he was led to resign. Groff brought a lawsuit under Title VII on the grounds that they could have accommodated his religion without undue hardship on the conduct of the Postal Service's business. Next slide, please. So this case provides a clarification, and as I said earlier, is a significant shift from prior precedent. So in Groff, the court determined that this de minimis standard, the way it had been interpreted in prior years, was actually a mistake, and that the employer must meet a higher standard in order to deny an accommodation request. So in this case, the court determined that the employer must show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. So this is quite a contrast to what was formerly the quote unquote de minimis standard. Now the employer has to show that there's substantial increased costs in relation to the conduct of its particular business. So the burden of denying a religious accommodation has now been significantly heightened. So now an employer must do more than conclude that requiring other employees to work overtime would constitute undue hardship. That's simply not enough. And other options such as shift swapping should be considered. And I will say that the court ultimately bounced this issue back to the lower court and also determined that it's a factually intensive analysis. So while it clarified the standard in this case, it didn't reach a conclusion as to what the appropriate outcome was with respect to Groff. Next slide, please. So what does this mean for you? So as I mentioned a moment ago, the court really hasn't, despite clarifying this standard, it hasn't provided any specific guidance on how to apply it. So it really requires a case-by-case analysis. So like the reasonable accommodation analysis that I spoke about earlier in this presentation, it's really important for employers to engage in the interactive process with employees to request these religious accommodations to see if you can find a solution that works for everybody. So either provide an accommodation, or you're going to have to be prepared to demonstrate and document that the employer simply cannot provide that accommodation without an undue hardship on the employer. And now, as we talked about a moment ago, undue hardship is no longer a de minimis impact, but now it's showing that there's a substantial increased cost in relation to the conduct of its particular business. So all accommodations should be considered, not just those requested by the employee. And I will just note that Groff did make it clear that Title VII doesn't require an employer to violate seniority rights as part of a reasonable accommodation. Next slide, please. So some practical advice in performing this clarified analysis. It's important to ask questions such as, in the face of a request for a religious accommodation, which operations are going to be impacted if we provide this accommodation? Is there any work that can't be performed at all? Will this impact revenues? I know that's not as much a question for schools. How will students be impacted? How will others be impacted? How will the colleagues and other employees be impacted? The types of accommodations that could be requested for religious reasons that are in play here are, for example, vaccine mandates, dress codes, or altered hours of the work days, as was the case in Groff. I will say as a final word, it's really important to review your policies and procedures here to ensure that you comply with a clarified standard and to train your staff on how to make these decisions under the new standard. And I will just emphasize as my final word that engaging in this interactive process is incredibly important, because I think it's super important to show that you've tried to work through this issue and try to find a reasonable accommodation. Particularly if you're going to deny it, you have to really show that there's a significant effort by the employer to try to come to a mutual resolution of the issue. Thanks so much. I'm going to turn it back over to Bettina.
Thanks, Jill. So that was a lot of information. I thank you all for hanging in there for the whole presentation. We hope it's been helpful to you. I want to again say thank you so much to the MCPSA for inviting us to come speak to you all today. As a reminder, you can submit your questions in the Q&A or the chat. We'll aggregate those and put them into a Q&A document that we'll send out to you as a reference. We'll include some other information that we covered today, and we'll share the slide deck as well. So you can, again, put them chat Q&A, or you can also email them to Patricia Gary, who is our assistant. She's kind of our crackerjack assistant with the presentation, and she's going to be helping to collect comments and questions. So you can always, if you think of some later, you can feel free to email those to her as well. So thank you everyone for joining us, and it's been a pleasure, and I hope you all have a great rest of the day. Thank you.
Thank you, everyone.